Hello friends, Mandar here. I'm back with another video. Today we'll talk about three topics. A federal judge in Boston has made a judgment regarding the 100,000 fee for H1B. The judge has termed it as illegal. So we'll talk about that. We'll talk about the adjustment of status memo that came a couple of weeks back. There are a few more questions regarding that. And we'll talk about what's happening with the regulation change with the student visa. So a lot of important topic, guys. Watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration and lifestyle related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now check out the links in the description because those are affiliate links. And if you find something interesting, you'll also be helping the channel. And while you're down there, don't forget to hit the like button. That helps propagate this video to people who are interested in it. Also, don't forget to put a meaningful comment or a question that you might want to get answered from the community down below, because that will get you into the giveaway by the end of this month. Now, with that said, let's jump into the first topic of today, which is a federal judge in Boston strikes down Trump's 100,000 fee on the new H1B visas. So this came in yesterday. A federal judge on Monday struck down the Trump administration's 100,000 fee on new H1B visas, contradicting to an earlier federal court ruling upholding the fee hike. Now this is interesting and we'll talk about it. The administration announced that much higher fee as a way for preventing foreign workers from taking American jobs, but US District Judge Leo Sokorin in Boston sided with 20 states and struck down the visa policy, concluding that the executive branch exceeded its authority and violated the Administrative Procedure Act, which governs how federal agencies develop and issue regulations. The court finds that the policy imposes a tax on H1B petitions without the requisition delegated by the Congress. Now, the point that this judge is making is the administration is in a way putting 100,000 fee on H1Bs in lieu of a tax. So this is really a tax, and whenever it's perceived as a tax, it is a Congress decision, not an executive branch decision. So that is the point that they are referring to. Also, they are saying that this did not follow the Administrative Act's procedure, which has a certain procedure established by the Congress, which is that the policy should be published. It has a commenting period, it has a wait period, and only after that feedback is taken should a policy be enforced, which was not done in this case as per the judge. So the judge has stopped this. Now there is another point, because there is a DC case that was in the appeals court in the Washington DC, which actually upheld this decision of 100,000 visa. So these federal judges are contradicting with each other. I don't know what's going to happen, to be honest. This is not a nationwide injunction, but this is kind of a final decision. What that means is they have considered all the facts as it relates to this case and made this decision. So the judge has asked that this fee cannot be implemented, at least it's illegal. So that's what the judge is saying. Now again, this is not done and final because the administration has 60 days to file an appeal. Again, it will go to the appeals court, or it might go to the Supreme Court. Wherever it might go, this will still continue. So in the meantime, what happens is the real question. So in my opinion, the government is going to file the appeal, or they are going to take it to the next level of the courts, which is senior courts, which is Supreme Court. And that decision will be final, but that can take weeks and months. Even the appeals process can take weeks. So in the meantime, what happens? Now, to put this in context, not much has actually changed. This 100,000 fee that was announced a while back, that was actually a lot scarier than facts on the ground. As I understand, there were only less than 100 cases that actually went through and actually paid this $100,000 fee for the new H1B. So it's not a significant number that we are talking about, but it definitely had scared a lot of employees to sponsor H1Bs, especially the new H1Bs. So that might be the reason why this number number is so low. But regardless, this is going to be a big impact. If this order stays and if the government is not allowed to gather $100,000 fees from these new H1B employers or petitioners, then there will be an increase in the demand for H1B, and employers will be willing to sponsor H1B more and more, because you know the job situation right now, a lot of layoffs, a lot of people in the market, a lot of those people who are in the market are also on H1B, and employers are scared to file these new H1Bs because they have an additional $100,000 price tag which they are not willing to pay. So by lifting this $100,000 fee, it is likely that more and more employers will be willing to sponsor H1B. So that will be a good news to the market. But what happens on the reality on the ground is to be seen. Whether this takes into effect immediately or whether there is a stay put by a appeals court on behalf of government is to be seen. Now, basically, if you talk about this lottery season, whoever's application is being picked, they can go ahead and submit their full H1B petition without fearing for what happens with this $100,000 fees. I would, if I were in your shoes, if I'm picked in the lottery, I would definitely file for the full petition of H1B without worrying about what happens in the future. But what I will not advise is taking this on the face value and saying that there may not be a $100,000 fee and going and setting up an appointment in the consulate to get your H1B stamped. Now, we don't know how these policies are changed, how long it takes, how it's going to affect, whether government is going to file the appeal immediately or whether they are going to take time. We don't know that. So there is still a risk in going to the consulate to get your H1B stamp for the first time. So that is still a risk in my opinion. Now let's wait and see what happens. In the meantime, if you have any specific questions, put down in the comment section below or reach out to me on Calendly if you are facing this scenario and if you want to talk to me about what I would do if I were in your shoes. You can find that link to the Calendly in the description below. Now let's talk about this policy memo which came for adjustment of status. There was a lot of scare, a lot of things have calmed down because the interpretation of who is impacted by this policy memo for adjustment of status are not going to be those people who were already on H1 or L1. Obviously, there is going to be a scrutiny. It will all depend on what was your original intent coming into the United States. Was it a dual intent? Like if you came on H1B or L1, it's already a dual intent. So those people who are in the adjustment of status will be less impacted. But in my opinion, if you had come over here on student visa, which is F1 visa or visitor visa, those are the things that will be questionable on behalf of USCIS, which will then prompt them to question you regarding your intent or original intent. How did the intent change for you to be for you to apply for permanent resident? So that is my speculation. So if, in my opinion, if you are on any dual intent visa such as H1 or L1, you should not hesitate to file your adjustment of status. I don't think there is going to be any. I'm sure there will be some level of scrutiny or some RFEs that will come in, but those are not the people who they are targeting. Continue to file your perm applications. Continue to file your I-140 applications. Those are not going to be impacted. Adjustment of status is where the question is, and if you happen to be in that dual intent original visa, then you should not worry too much about it. Now, if you are on the non-dual intent visa, such as F1 or B1, B2 or TN on those sort of things, then that's where you need to be worried about, because in those categories of visas, even if you have changed later on to the categories such as H1 or L1, they're saying they will still go back to the original intent to question whether your intent was legitimate at the beginning. So those people should consult with a good immigration lawyer before filing for an adjustment of status. If you want my opinion in your particular scenario, reach out to me through Calendly. That link is in the description. Now, the biggest impact, in my opinion, is for overstayers of the visa. People who have violated their visa terms, people who have overstayed their visa, who have had unauthorized work in the past, whose visas were denied in the past, who had some encounter with the law enforcement, DUI, domestic violence. Those are the type of situations where you have to worry about in the adjustment of status. That is my opinion. So put down in the comment section below if I haven't answered any particular question in regards to this adjustment of status policy memo. Now, the last topic I wanted to cover is the regulations or rule changes that are coming in F1. Now, there will be an elimination for, say for instance, F1, there will be an elimination of status fixed period. So there will be an elimination of duration of status. They will go to a fixed period visa, which is more likely to be a 4-year visa for F1. obviously with an option to extend. Now one has to remember that I-94 controls how long you can stay in the United States, especially if you're on non-immigrant visa. It's not the visa stamp, it's the I-94. So that is what is most critical. So when students reach out to me saying that I have been on day one CPT for a very long time, like multiple years, more than 3, 4, 5 years, you have to be worried. If you are not maintaining your F1 status, if you are not maintaining your I-94, and if you have some discrepancy in your DSO or service status, you could be in trouble. I have seen students getting rejections for their OPT extension because they did not maintain their SEVI status or their F1 was closed, have any other visa to go on to. And if you are overstaying the visa, if you as long as you are under 180 days, you can file for a waiver. But if you cross 180 days, there is automatic 3-year ban. If you go outside of the United States, you cannot come back for 3 years. And if you have overstayed for more than a year, then that ban is 10-year ban. You cannot come into the United States. You will not get any other visa to come into the US if you leave, and if you have been overstaying for more than a year. So you have to keep that in mind. Many people don't pay attention to their I-94s, their status. They think that as long as you are studying, as long as you are on CPT, day one CPT, especially the day one CPT, it is a gray area. Many people think that this is a law or this is correct policy. That's not true. It's debatable, it's misinterpreted, and it's a gray area. So if you are on a day one CPT for a very short time, and if you have a coursework, full-time coursework that you are able to establish that you are doing, then that's a different story. But if you are on a day one CPT and you are continuously doing a job for years and years without enrolling or without having any full-time intention of studying based upon which your day one CPT is existing, then you are in trouble. I came across a couple of cases recently where people thought that they can work on day one CPT indefinitely as long as they have an enrollment, which is not true. You have to be very careful there. So it is very, very likely that students can fall out of status if they don't know the rules. If you want my opinion regarding your particular situation, contact me or contact a good immigration lawyer if you think you have fallen out of status while on F1 visa. So that's really all I wanted to say in this video. If you like the content of this video, if you did, hit the like button and consider subscribing to my channel, and I'll see you in the next one.
And that brings me to the sponsor of today's video. Have you ever done the Google search of your own name? Look what I have found when I did mine. Here's what comes up. While some of this information is relevant, the other makes me uncomfortable that my information is exposed for a sale like this. Data brokers sell your information to scammers, spammers, or anybody else who may want to target you. Your full name, email address, home address, your relatives' names, health information, it's all out there. That's why I have been using Aura, sponsor of today's video. Aura shows me which data brokers are selling my information and automatically submits opt-out request for me. Cleaning up my information not only helps reduce the amount of spam I get, but it also protects me from hackers who could use this information to help them access my social media accounts, bank accounts, or other sensitive information. Aura does so much more to protect my information and my family's information from online threats I can't see. I get other features like antivirus, VPN, password management, parental controls, identity theft insurance, and more without having to download several different apps. It's really easy to set up, and best of all, I get everything for one affordable price. You may already have one or two of these tools, but not having Aura is like locking the front door but leaving your back door wide open. Aura is always on, doing the hard work of keeping me safe so I can focus on other tasks with peace of mind. I value my privacy and I value yours. You can go to my link which is on the screen and in the description and start your free 2 weeks trial. So protect your information, your family, and have a peace of mind. That's Aura.